Uh, hey everyone, I'm Anubhav Garg, Management Trainee from LawSikho, and I welcome you all in our session A to Z of Career in Competition Law. And today, as a subject matter expert, we have Swati Sharma with us. Thank you, ma'am, for being here.
Thank you, Anubhav. Thanks a ton for inviting.
Ma'am, for the sake of our viewers, why don't you start with your journey as a lawyer?
Well, that will be quite an interesting one, if I should say. So, I have graduated from the Faculty of Law, University of Delhi, in 2017. So, I'm now in the third year of my practice. So, right after graduating, I had joined the NLUD campus of Center for Information and Competition. If you have any idea about research in competition law, so I worked with them. I worked with the Kutz Institute of Regulation and Competition as a research associate, again dealing with competition law issues, what goes into research in competition, again, which is something which is very not so prevalent in terms of, I would say, Indian legal scenario. So that's what I did. And after that, after working there for 2 years, I joined Parthak and Associates, which wherein I am now a competition law practitioner with.
Okay.
So that's how the journey has been, quite tumultuous. I have sort of tried grappling my hands within all sort of scenarios that could be possible. So yeah, so it's
Great.
been some sort of research, some sort of law firm experience, or dealing with the size of academics in competition while drafting courses, readings, presenting projects to the CCI hearings, presenting views from the stakeholders, getting impaneled, and all sort of things that were a part of my journey so far.
So, ma'am, my first question to you will be, what's so unique about competition law that there are so less lawyers actually practicing it? Even law firms have adopted a separate hiring procedure for competition lawyers. So, what makes competition law so unique?
See, competition law is all about how the market operates. It's essentially a market-oriented law, and I'm not saying it in the wrong sense, or I'm not saying that it's a capitalist approach. Basically, it approaches every player in the market, however small you may be, however large you may be. So again, one set of the question that you asked, that there are very few lawyers practicing, I would try to sort of disagree with that, because as even like you would see more and more people coming into the field, why we would see that there are quite a few lawyers practicing while in the initial years is because the law was just coming up. It's a relatively newer section of law that has come in, just started about in 2009, and we are just in a decade in. So with the size of, say, with the recruitment structures of the law firm, which have considerable team of 15-20 lawyers, all of them, I would say that's a considerable size. It's not a smaller practice area with a few lawyers anymore. Again, now
Ma'am,
coming to
there
your
are less than 250 lawyers actually practicing competition law in all over the India. So, I don't you think that it is a practice which it
again,
is a
that's what I was coming across. Initially, you would see, yes, there were a few lawyers, but the size is gradually increasing. The teams are gradually increasing. You need to bring in right people. Again, addressing the second leg of your question, that what is so unique about it? Why is there a separate sort of hiring process for competition law practitioners? That's something that I would like to address now. So,
yeah.
what is unique about competition law is it only touches upon the market issues. So, until and unless there is a deviation in the market, or there is some conduct in the market, competition law does not come in. Now, competition law after 2011 has also started targeting the merger control filings. So, after a certain threshold is exceeded, you need to filing with the Competition Commission. Guys, just give me a moment, yeah. Yes. So after this sort of increases, you need to make a filing to the Competition Commission. Now, since the merger control rules have come in, you would see the size of people actually getting. You would see the size increasing for the law firms. Now, every team will have 30, 40 people generally, if not 30, 40, let's say 20. Then again, that's the service with the law firms. There are quite a few boutique law firms operating now that are only focusing on competition law. Then there are independent practitioners in competition law, which we would not worry about so much, because then again, we are, as students or as someone who's getting a view from the sort of things on internet, you would only see some of the law firms appearing on. You would not actually see the independent practitioners or the advocates that CCI impanels. Then comes your policy makers. So who are again advocates, who are dealing with researches, who are dealing with whatever is happening around the global policy scenario. Then there are people that have been engaged by the CCI. So I would sort of disagree that the number is limited to 250. It's quite a lot again. So one needs to understand that the law and the lawyers that work in are not just limited to law firms. Please give a holistic, like please sort of experiencing more, see that there are other people who are working as well. It's not just limited to law firms. Look at independent litigators again. So addressing your second leg, that what is so unique about competition law? Again, as I've been saying, it's a law about market. So unless and until some specific conduct happens, there would not be an investigation. There would not be something that triggers off, which has been happening a lot. I'm not saying that there are no activities in terms of competition law, but the conduct compared to other areas of law would be relatively lesser, because again, lesser companies would be impacted by it. The market in the whole is impacted, but the action trigger will be with some companies or some entities. So therefore, we need to understand that while we are making a comparison, we cannot make a comparison with all generic sort of laws that are prevalent here. Let's just limit ourselves to um, specific markets and everything that the law would operate in.
Okay, ma'am. And why there is a separate hiring procedure in tier one as well as in many boutique firms for hiring competition lawyers?
See, again, competition law in terms of practice is quite different from what other law would operate, or how other laws kind of work, right?
In what
So
aspect,
while
ma'am?
you're making, yeah, sorry, Abhinav, you were about to say something?
Yeah, I was telling you mentioned that it is different. In what aspects it is different
There,
from other laws?
yeah, that's what I was trying to deal about now. So how it's different from other laws is that while dealing with whatever other laws, let's say an example of criminal law,
Okay.
while you're looking into the conduct of, say, what's the person who has committed a crime and accused do, you're just looking into the conduct of the accused here, right, vis-a-vis the crime. Again, if you say let's look into a civil suit, you're looking into the conduct of whatever the plaintiff has done or what is the wrong that the respondent has done. If we look into arbitration, you're looking with the conduct of the two parties concerned. What happens in competition law is it's actually a proceeding in rem. So we're looking at the entire market. We're not just looking into the conduct of one party or two parties here. We're looking into the conduct of the entire market. So if, let's say, an investigation has come about on Amazon, we're not just looking into how Amazon works in the market, but we're actually looking at how other competitors are functioning in the market. So you're looking at Flipkart, you're looking at other similar entities, right? If something comes up in, say, so the very famous, the auto parts case that I'm sure every young lawyer, whoever has joined us, all the students are familiar with the case. So while dealing with that case, you're not just looking at the conduct of, say, a Hyundai or a Honda or a Steel or a Fiat. You're actually looking with every car manufacturer there, all of them that will be impacted. So that's something which is different from other practice area. One, again, so because it's so extensive, the kind of work that goes in again becomes quite extensive. The filings are very extensive. The research that goes is very granular. Uh, we look at in all sorts of data. You're dealing with balance sheets. You're dealing with whatever is the sales. You're dealing with. You see, somebody had just raised a question on whether we see the impact of the player. If that person can just repeat the question on the chat box. So sorry, I missed your question.
Ma'am, we can take the questions at the end.
Yeah, that would be much better that we take the
Yeah.
questions in
Yeah.
the end. So again, while coming with the filings, that will be extensive both in case of your antitrust side, which deals with your issues on anti-competitive agreement and abuse of dominant positions, as well as merger control, wherein you're giving information about every possible thing that your business does, right? And how it will not affect the market once the things come into being, once the merger is consummated, or how your conduct is not affecting the market in terms of uh, that you're not abusing your dominant position, or that the agreement that is not adversely affecting the market. So again, the research, very, very granular research that will go in. You will be dealing with case laws from not just your jurisdiction. You will be dealing with case laws from foreign jurisdictions. So you have to be sort of updated with the case laws there. You have to constantly check in the market, that how the market is functioning. You need to be updated about the market. You need to keep on seeing every change that is happening in the market on a daily basis. That's something that you're addressing in your filings, be it on the antitrust side, be it on the merger control side. So that's where, so if I am a recruiter, say, I would want somebody who has certain insight into it.
Precisely.
So see,
Precisely.
it's now how, so basic, my point of telling you all of this was to see how different it is from the other practice areas that one is generally exposed to. Unless like you step on the ground, you're not really would know that how it goes or what goes into making a competition or filing. So that's something that the recruiter would look. Do you actually have an interest in the market? Do you sort of see how, and I'm not saying that interest in the market would mean that you are aware of everything that's happening in the market, but at least aware of how things in the market are going on generally as a general trend.
Yeah.
We're not supposed to know uh, the conduct of every enterprise that is functioning out there, but what's really going on in the market. So if example, you're not just looking at how the competition size is functioning. We generally look at what happens on the insolvency ends as well. We generally look at what are the chances that the companies would try to acquire, or how the company is dealing. Would there be something that they're looking for an acquisition? Is there something that they're trying to merge? That you sort of get on from the conduct, whatever is happening in the market, from
Precisely.
the news itself.
Yeah.
So the recruiter would try to look at that in the first place. And the second instinct is, uh, like once that leg of checking your interest goes in, then they would try to see how you write, how sort of uh, is your presentation, how in depth can you go. Because again, as I've already mentioned, that the kind of work that goes in is very granular. So it's not something that would be exciting for a day and then you are not exciting, then you don't find it exciting the other way around. Because uh, the rounds of litigation goes on for months, merger
Yeah.
filings to make, which you would see a 50-page order. I am saying on the best case scenario, a well-reasoned merger filing case might run into say 20 pages, 25 pages, but actual amount of work that goes in takes months. So somebody who can have sustained interest. Now, it's not a day's job, right? And
Yeah.
also, if you can be that detail oriented, the deadlines are tough. So how well are you be able, how well will you be able to cope up with those deadlines? It's not something that the law firm or your senior, if you're dealing with an independent practitioners, would like to do, but it's just the nature of the job is as such that it would require you to work on stringent deadlines, long working hours and everything. So how well all of these things come into play, while I would think when the recruiter is saying, then again comes, if at all you fulfill all of this, then again comes that how well you have been acquainted with the law. Again, these
Okay.
are some things, the practical aspects will be something that you would only learn once you have stepped into the job. But ideally, a recruiter would want, somebody who's recruiting would want that you have some acquaintance with the law, some acquaintance with how the act actually plays out in perspective for
Yeah.
everyone.
The events
So
which are relevant to the organization you are applying in.
of course, that's something that actually forms in part of your research of where you are applying to. But these are something that's very generic that will be applied everywhere. It's
Yeah.
not just specific to a law firm that you are applying, or specific to a litigator that you are applying, or whether you're applying with the CCI, or you're applying to some research institution, or you're trying to get your LLM or whatever your future plans might be with respect to competition law. It would be uh, generic wherever you sort of try to make an application, that you sort of prepare yourself for all the steps, that you are aware of the market, that you're aware, you diligently show your interest. It's not just something that you show it in your CV, you actually need to have it.
Yeah. So, though I'm very satisfied with the answer you have given, just for the sake of clarity, can you give us 4 or 5 pointers of uh, what skills a recruiter looks in a potential hire for competition law?
Okay, so for everyone out there, that's something that I have faced while I was trying to look out opportunities after my law school. I had been lucky that I had interned at the places and got sort of acquainted with how competition law functions within those parameters. And something that I've really learned over the years, like during my internship experiences, as well as how when I see interns around me, that first of all, that they would check is, what is your interest? Are you actually interested in the law? Again, as I've said, that it's not something that you can take up for a day and then leave. It's nobody would want to hire someone who would be interested or who could work for a certain time and then be dazed off with.
Yeah.
That's something that a sustainable interest, and it's not just limited to competition, no, it's for anything.
Yeah.
A passion for work is something that a potential recruiter would look at. It's whether you're a painter, whether you're a chef or whatever. So the
Yeah.
first step obviously goes on into being passionate about the job that you're applying at. Secondly, they will see how detail oriented you are, and it sort of comes out in the way that, say, let's say that you're interning and you have been given a case law research. How well do you present your case law research presentation in terms of content and in terms of the document is equally important, right? Because our job at the end is to present the information to the CCI in such a manner that the complex scenario of how a business functions is sort of given out in as simplistic manner as it can be. So, for example, say I have given you a case. For any intern, we give a case law research, which is most generic work that an intern will have on the first day or on the second day of your internship, is to find case laws on the relevant proposition that whatever you will be. So if you are able to draw parallels of that case law, you find a case law, say I am giving you research on how in a particular situation and an enterprise that is dominant is trying to do price discrimination, but I need you to find the justifications that what all would be the situations wherein a dominant entity can do price discrimination. It's a very generic competition law research proposition, and there are way too many case laws to find economic justifications of price discrimination. But an ideal intern, why, and this is all sort of while you're doing your internship, you're being assessed, and that's something that will happen. So not just limiting yourself to competition law in India, you can draw parallels from the EU jurisdiction, from the US jurisdiction. Also bring in what is a recent uh, outlook on it from some research paper, from some news article. Something very unique about competition law and the filings and researches that we make is that we sort of take into perception and admit as evidence, also submit as evidence, news articles, news reports, research papers, which is unique. We don't do that in criminal law filings, or we don't do that in civil suits, we don't do that in arbitration. The researches there are primarily just restricted to case laws and what has happened in the past. But here you're actually looking at the present conduct of the entities as well. So if you sort of have an idea of what the entity is that we're looking at, then you look at the areas of those entities. Otherwise, you look at whatever is happening in the market in general with respect to price discrimination. How is the outcome in what is the outcome in all sort of jurisdictions? That will help. That will make you stand out. That's something that every recruiter looks at, that how granular, how detail oriented you can go, right? That would be your second part. Third of it would be again knowledge of the market.
Knowledge.
Now that we know that you have a passion for law, you have sort of whatever it needs to go into this, is how you must know how the market functions. You must know what is happening currently in the market. For that, you need to look into the newspapers. You need to sort of have a grab of hands on the news on the commercial sides. What all? Again, I would repeat that competition law is something which is very market oriented. So you need to look at the conduct of all the sort of major companies around the world, not just limit yourself to India. See however the companies are functioning around the globe.
Yeah.
So that's something that you need to know. Fourth of it would be how you're updated in sense of cases that has been happening. So an ideal candidate for me, or anyone who would say come to me for recruitment, will be if they fulfill all three parameters. Are they now updated with what is happening in terms of competition or jurisprudence in India? If at all you know that what are the latest cases, if all you know where the CCI is coming from, what are the views that if they are forming. Additional, if you know what all the CCI has been tackling in terms of market studies, in terms of its approach on where it's going, sort of someone who has a vision, someone who can have good analytical skill of dealing with everything around and sort of making a persuasive argument out of it, dealing with while talking to me, sort of convince me of his argument. It might be against me, but if we sort of try and bring up some good deals or argument on their own side. So again, I'm looking at an analytical mind who deals with nitty-gritties of it. Win-win, I will hire him straight away, and so will other recruiters do. Not that I am in a position to hire you guys, just giving an explanation of would what would a potential recruiter look
Yeah.
at.
Yeah.
These are some things that I've also learned during my internships and during my interviews as well, that I have been asked to sort of defend a position. Okay, so something that during my PPO interview, what I was asked to, there was this tier one firm that was dealing with a new sort of market area, which is now quite famous in the digital economy. So they were dealing with the conduct of that. They were defending that player in the market, completely new market, and I was to sort of agree with the informant. While I had been working on that case for say 2 months, I had been trying to defend the opposite parties on every level and ground. During my interview, I was asked that how would I defend the informant? How would I sort of oppose all the arguments that I had been preparing for on the sides? So those sort of things, like ability to challenge and ability to um, sort of give a opposite view on the minute, on the go, and be that present, is something that we would look at. That's something really great if you can bring in, guys. That
Great.
obviously will come across with a lot of reading.
Yeah.
There's no going back on the reading in competition law, guys. Okay, not just competition law, any law, but competition law requires you to get that extra step.
Great. Great. Nicely put, ma'am. So, ma'am, as you have mentioned that competition law is comparatively new, and people are not aware of it that much. That's why they don't prefer it over the conventional areas. So, can you please enlighten us on the part what task constitutes the job of a competition lawyer? What are the tasks they do very often, and these sorts of things?
Right. Okay. So a typical day for any competition lawyer would be to, again, what any lawyer would do, read upon their filings, advise the client. So we advise the client on any competition lawyer would sort of advise the client on what all would be the potential outcomes of their conduct. If at all you sort of prepare in advisories for them, that wherein they will fall foul of the competition law if they do say X activity or Y activity. So preparing advisory is one. dealing with the cases that are pending with you. You go and sort of draft researches, you you draft your information or your response to the information, which is very typical of any lawyer. If you have a case at your hand, uh, that's how you start your day with. Then interact with the clients, briefing the senior lawyers on whatever is the matter at hand. If you have a merger control filing, looking across the stages. One thing that's quite unique with this is hounding the CCI. So we sort of always go back and forth with the CCI in terms of whatever has been happening with respect to the other parties. If there has been any document that has been filed by the opposite party, you sort of go in and inspect. You sort of keep a track of what all has been happening on the end of the opposite party. You keep a track of what all the cases have been admitted. All at every forum. You would track in the CCI, you would track in NCLAT, you would track in Supreme Court, you would see at the major high courts whatever is happening. You keep a tab on the case updates that have come in, whatever new cases have come in, you read, you brief your clients if it affects their business area. Again, you're not dealing with one client, you're dealing with multiple clients at the same point in time. So it's bound that one order will be affecting one or the other of your clients. Even if it does not affect, you sort of try and bring in the repository. You see that how it can be helpful or how bad it will be for the clients, because the CCI can again then come in from the perspective. So all of this is something that we will do on a day-to-day basis. Additional from that, again, something say some urgent information has come in or some urgent query has come in, so you sort of do advisory as well, which is over and beyond everything that you have been doing. Then again, competition, which is something that's new that the competition lawyers have been doing now, is competition compliance trainings. So a lot of multinational companies, because it's a new law, because companies and entities are not aware of where and what of their conduct can fall foul under the competition law. So we have now not just we as in the entire lawyer community now has started, the competition lawyer community now have started giving trainings to the multinational companies, to entities that can fall under the competition laws perspective, to how to avoid any competition law issue under their business model. So you will tell them what all how a meeting can be construed, what all representations can they make, can they not make, how their small acts such as having a telephonic conversation with the competitor can be seen as an anti-competitive practice within
Yeah.
the CCI's term. How just like a media statement that when you're oversighting your shares can fall foul under competition law and can attract a competition law violation case against you. So all these things, compliance, how to, the latest thing that we're doing and the hot shot in the last a year or so is trainings on dawn rate. Now the CCI really jumped up its practicing dawn rates, which is for the uninitiated, a search and seizure operation that the DG from the competition commission does on your premises. So to find evidences in case of the opposite parties. So that's something that we are really training the company authorities, because then some might have lawyers, some might not have lawyers. How to respond to the challenges in those areas is something that lawyers are doing now. So it's pretty, so I'd say it's very dynamic. Any day in a competition lawyer's life will not be the same. You will sort of be dealing with the same law, but in different aspects every day. Also, one thing which is very, I mean, I find interesting in competition law is that you would, with every new matter that you're doing, you're learning quite a lot on the business of a particular market. So, for example, if you're dealing with, say, an Ola and Uber, you know, you have to know ins and out of the radio taxi industry at all, because again, like I would at the cost of repeating myself, you are not just looking into the conduct of your one party, you're looking into the conduct of the entire market.
Yeah.
So you learn quite a bit on that, and it becomes really interesting at one point. So At some point you will find something which you had no clue about in your entire life. So that at point becomes really interesting. And then so I would say for any lawyer, 2 or 3 hours of a day easily goes into understanding the business practice of the entity that is their client and the competitors as well, and understanding the market. One thing that every one of us does is outside of our office hours or whatever is building upon our knowledge, is building upon or keeping ourselves sort of updated with whatever has happened around the globe. So we would sort of keep tabs on whatever latest guidance notes that the EU has passed on, or something that the FTA does, or what all has been the latest jurisprudence in US, say Australia. It's not just limited to India or EU at all. Uh, so as in how you update yourself depends upon your time, but that has to be done every day.
Great. Great. All right. Nicely put, ma'am. Very great, good answer. So, so as we have talked about what constitute a lawyer's job, what are the skills a recruiter see in a potential competition law hire. So, my next question to you would be: what are the initial workplace challenges young lawyers face while working in this niche, and how they can sort of prepare to cope up with them, and how young lawyers can distinguish themselves in the crowd? So let's start with the initial workplace challenges.
See, with any law, okay, guys, let's just put it this way: when you graduate out of your law school, you know law as it is in the books, is as it is in the bare act, while the workings of it is quite different. The law remains the same, but how it is put in, what all the back end works that goes on into putting a case to the court, from wherein the law that you have read in the books plays. So that fact is something that you would learn only once you start working. That's a challenge that every lawyer will face, irrespective of the practice area that they choose in. You go into a criminal law chamber. Again, you would know what CRPC has, what IPC says about a particular issue. Would you know how to approach the court? Would you know how to make a filing to the court? The court, your law will come into the place only when the appeal is only when the file is put to the court, right? So that's something, the back end part of something is what every young lawyer is takes time for everyone to sort of get boots on. And that's something similar that goes on into the competition law as well. You would know what an anti-competitive agreement is, you would know what an abuse of dominance is, you know what merger filing is, you know what dawn raid is, you know what gun jumping is. How does it actually come into play? Where does it impact your client? How are you responding to the client? How are you responding to the CCI? How are you sort of channeling your way through all of this? Is something that young lawyers understand, sort of go in. So the first time that you are doing an inspection of the opposite parties, you would understand that, okay, I cannot touch the documents, I am not supposed to write on the documents carrying a pencil. Something very personal, guys. I'll tell you that while you are making an inspection at the CCI, you inspection is something that you look in the uh, documents that have been on record from the opposite party side or from your side. So whatever information that CCI has on a particular case, whatever is on record, lawyers are allowed to inspect that and see and then prepare themselves accordingly, right? So ideally during that inspection, you take a pencil along with you, because you're not supposed to write anything on the paper. You look at the paper, you see what all has been submitted by the other parties. Now you have just one pencil, and after the point in time, they don't allow you to carry a sharpener or something. After a point in time taking notes, your pencil nib just goes off. What do you do then? This is some of the most vaguest challenges that you will face. You sort of learning to know that you need to carry multiple sets of pencils. That's as simple as it goes. Then again, you're drafting your first information. So what all can be put in as evidences? Your prudence will say, yes, I can put in this news article that sort of corroborates this abuse against the opposite party. But other additional sets of evidences can you pull in? what are the public data that you look in? Can you look into the private data of the party? How do you draft a confidentiality letter while you are submitting your information? What all? How do you approach the CCI in the first instance? I'm so sorry, guys. Now that you have made your filing, how do you keep track of what is happening within the CCI? How do you sort of update your clients on what is happening? Is something that's quite new to a lawyer who's just ventured in. You would not know it unless you sort of start working on. So everything is new, since everything is something that you have not touched upon until you started working on it, will be challenging for the first instance, but then you sort of learn your way through. You start and try seeing your seniors, getting advice from them, taking on the templates, reading on everywhere, taking additional courses and everything, that you sort of imbibe an idea. Once you're there, easily you can get through. Does that
Great.
answer your question?
Yeah, quite to quite an extent. So, okay. So, what is the? Though I'm very satisfied with the answers, just again, just for the sake of clarity, can you briefly give us two, 4, 5 pointers, just pointers, don't explain them, just 4, 5 pointers on how young lawyers can distinguish themselves from the crowd when they, you know,
Right. We've just completely brushed off that side of your question. I'm so sorry for the oversight. So again, how you can distinguish yourself from the crowd is by actually displaying your interest, by actually being really detail oriented, by putting in the relevant information whenever it's needed, be it by pitching that information to, be it your client, to your senior. Say for example, you have 2 hours to send across a draft. The team would not have the time to sort of research on everything and prepare the draft and everything. So for instance, that you know the sector, you know what all is happening in that sector, you know how the CCI is coming across, you know the case laws of it. I'm not saying that anyone will remember everything that's happening, but you sort of have an idea when the uh, uh, query sort of approaches you, something kind of triggers in the back of your mind that I might have read. Then searching upon it, researching upon it becomes relatively easier, as opposed to something that you have no clue absolutely about. So all of those things, your reading precisely in everything will be of great help to you while you try to distinguish yourself within the team. While you're joining also, there will be 5 lawyers that are joining with you, all freshers. Distinguishing yourself within that fresher and within the team itself also becomes uh, a challenge, right? So your reading will help you there. How well can you put your thoughts across? Be eloquent about your thoughts. How precisely can you put your thoughts across to the clients in smallest and the simplest of the words, but actually say everything that needs to be said, is something that will be really helpful for any competition lawyer, and for any lawyer for that instance. Just putting complex jargons across to your client in the simplest way is something that can take you to lengths.
yeah, great. Okay. So, communicating with the client is one. Second, you mentioned is
Just
being up to date, update.
updating yourself with everything becomes your second priority. Third becomes your presence of mind. Fourth is your dedication and passion towards your job. All of this, if you have, you are, there's no stopping for anyone.
Okay, ma'am. So, Uh, so now we know that we see at multiple sites that companies like Ola, Make My Trip, Google, Oyo, Amazon, Flipkart, Google, Adobe, and these are heavily looking for competition lawyers. Also, unlike many other areas of law, when you are entering into this niche, you are expected to have a certain level of skills. You are not. It's not like other law areas where they work with the presumption that you if you are industrious, if you are upbeat, then we can build upon the technical skills. They expect you to have a certain kind of technical repertoire as well. So ma'am, if someone has to score a job in the companies I mentioned, these are tier 1, so what kind of skill sets do they look for? Is it any different from what other not so incumbent organizations are looking for, or what's your insights on it?
So for any competition lawyer, one thing that becomes your Bible or your manna is to know the business of the companies that you are
Yeah.
tackling at. So for example, all of the companies that you have mentioned are sort of the digital companies, or what we call it, the hipster companies in antitrust parlance, right? So all of these companies, somewhere or the other, work on similar models. They sort of have heavy repercussions on data collection, how they do, what they are looking in terms of how they're interacting with their consumers, what are the mechanic that goes into it. Something that you know how the model of the company works goes on to long length. That's very basic before you are actually even trying to say set up an interview with that organization in the first place. You need to know that what is happening, then sort of fill in that whether you would be interested in working in such an organization or not, right? Because you are certainly restricting yourself to one similar set of practices that will happen within the organization. Again, after that, when you have filtered in the step of whether you would like to apply for those companies or not, all of these companies would require you to have knowledge on how digital economy functions. What are the latest happenings in the legal scenes for these digital economies? You just not need to limit yourself to the conduct of, say, Ola in India. You need to see how its competitors are functioning across the world. You need to see, if I am going for an interview at Ola, my interviewer can sort of ask me what are your views on the Uber case that is happening in European Union. What are your views on how Uber is paneling out in, say, United Kingdom, or it's happening in US, right? If I go to an make my trip sort of an organization, they will certainly ask me, are you in agreement of what all booking.com, which is a similar platform as make my trip, across is functioning in the Europe? Are the antitrust cases against booking.com justified? If something that happens to me, what are your outlooks, that can those challenges, can those allegations be posed against me? If at all they are posed against me, how will you be justifying those challenges against me? How will be justifying the allegations? What are your thoughts on it? So that's something that the organizations will ask. So first of all, after knowing that you are kind of trying to push for these organizations, you need to look into whatever is happening within the industry for those organizations. Again, they would like to know you they like you to know about whatever uh, at very granular level, to understand the challenges in terms of filings with the CCI as well. So now that you would be venturing as a lawyer for a particular organization, you will also be interacting with the law firms that will be acting for you. You will be interacting with the CCI. You sort of need to see, they will not be reaching out to the external lawyers or for the law firms to reach out whenever their conduct falls foul under the Competition Act. They will sort of expect you to know that and to inform the organization accordingly, that what is the conduct that will fall foul. So for example, here, if I am raising my prices on the platform uh, on a per day basis, will that impact my filing? So during that sort of thing, you need to tell your prospective recruiter that yes, this can fall foul under the Competition Act, so you might just stop it. If, say, Flipkart gives you a big billion days, or Amazon gives you the sale that it does, the Great Amazon Festival, it's heavily discounting. So would that under any circumstance fall under the conduct of predatory pricing? some all sort of things is what they will look at a young lawyer or any lawyer, for instance, to know. Then again will come your issues with mergers and acquisitions and everything, that what will be the threshold, when are they crossing that threshold, when do they need to make a filing. Of course, there is an assistance from the external counsel, that will be a law firm that you engage with, the senior lawyer that you engage with, that will sort of give you perspectives on when and how to approach it. But the first trigger will always come from the internal counsel, and that internal counsel should be you. So all of this is something, being, again, I am repeating myself time and again, that being updated here is the key. And being updated here is key for every lawyer, right? The forum, the kind of place that you are practicing at does not matter. It does not matter whether you are a lawyer for a law firm or an in-house counsel or whatever. You need to be updated.
Great.
So these some very basic skill sets will be these, that the first triggers and everything that a lawyer should know. If I can sum up, then again I will say that to know when to initiate compliances, to know when to sort of seek assistance with the external counsel, to know what all practice would fall foul, and then seek assistance, or in fact sort it internally, is something that companies would definitely look on while they're potentially hiring. So you need to be really thorough with the act. You need to be thorough with the decisional practices of multiple jurisdiction. Again, all of these companies are not just limited to India. They have their businesses across the globe. So it will be not limited to only knowing what is happening in India, or sort of say, okay, and Uber might seek assistance from their counsel in European Union or USA, but say Make My Trip or Ola that you have mentioned are essentially homegrown countries. So their companies, sorry. So their conduct initially primates from India itself. So how those things will affect, how well are you versed with the CCI's practice, how anything that they're doing in India can impact their global operations and everything, vice versa, is something that lawyers must know about.
Yeah, great. Now, as we have discussed the scope of employment in the competition law field, so let us now venture into the independent practice. So, ma'am, what are law firms job better than competition lawyers, and competition lawyers or in-house is the best? First, let us get done with this part completely.
See, it's really a matter of perception. It's not that a forum is better and B is not, or C is not, or there is no lucidity of moving from a said forum to the other. I might be practicing with a law firm today and sort of have that trigger to go independent the next day. I can very well become independent. Again, if I am independent today and I want to head back to a law firm practice or to an in-house practice, I can do that. uh, One thing that is different is that the kind of work that goes in is quite different. At an independent scale, possibly you're dealing with, I would say, dealing with the informants majorly, because the opposite counsels more often than not are huge multinational companies, or companies with good turnover, that would obviously want to approach in a law firm so as to get to the other side. So independent practitioners generally work on the informant side. To me, that becomes really interesting, because you're building the case from the scratch. You're trying to put across everything to say that this practice constitutes constitutes a contravention of the Competition Act. So that's something that an independent lawyer does primarily. I am not saying that it's limited to every independent lawyer, but generally that's what independent lawyers would do. Again, independent lawyers have a chance to be empaneled with the CCI. You would be representing the CCI at NCLAT and at Supreme Court or at the High Courts, wherever the challenges are put in for the order. So that's something that becomes really interesting with that you cannot do while you are at a law firm or an in-house counsel. You'll only be representing the clients that you have in. So the scope of work sort of differs here. Again, if you come at law firm practice, you have multiple clients, you're sort of grappling with different areas every day. You're dealing with those clients in and out, day in and day out. So that's something. Again, and now coming across to in-house practice, your um, scope of work is limited in the sense, I'm not saying limited in the sense of competition, limited in the sense of what is happening within the industry only. You're not expected or to look into the conduct of whatever is happening out of your market. So for example, if I am a counsel at Ola, I will be looking at whatever is happening within Ola, whatever is happening with the competitors, or whatever is happening in the markets that Ola functions in. As of now, they're operating in taxis and scooters and all of that. So looking at what is happening within the that market across the globe, in India and across the globe. So it differs on the scope. Now, what attracts you, how well it works out, is a very personal decision. And again, I would like to reiterate that it's not a watertight compartment. People move in and out all the time. In-house counsels come back to law firm very often. Law firm people start up their independent practice. Some flourish, some might come back. So this really interesting concept of being off counsel as well. I think you've had a session with Avinash, and there he had explained you how off counsels work. So you're essentially having you have an independent setup as well, and then you're engaged with the law firm as well. So any conflict of the matter, whenever you have, you sort of excuse yourself from that. Other than that, you're having the best of both worlds. So
Precisely.
all of that.
Yeah. Ma'am, can you illustrate a bit more on what is the scope for starting one's own practice in this niche? Like, can independent litigators shift their practice to competition law? What are the risks, if any? And yeah, these sorts of things.
Right. So for independent practice in competition law, the first set of, I would say, the first expectation that any lawyer should have is that you are not going to have many huge clients that will come into you for the first place. You need to start in from the informal side. Of course, if you have built in a reputation for yourself by working in the area for a considerable time, if you have worked with some law firm, or if you have been at the CCI for some time, been a research associate, or within the other tenet of the CCI have been engaged in any capacity, you have certain exposure to the law. Then clients primarily can trust you. Then the huge clients would obviously come. But at the initial level, any independent lawyer sort of deals with informant, deals with whoever is first starting with the case, whoever is bringing the contravention to you, right? So at that stage, what you face in first is the monetarily concept that I would try to bring in. That whenever you're working with a law firm, or whenever you're working in-house, you have a stable source of income that comes in. Now with independent practice, that stability of income sort of decreases. Yes, that's the first that one needs to take into account for every practice area whenever you're trying to go independent, is that there will be no stability of income. How again competition law setting up a competition law independent practice will be different from other practice area, again will be on the grounds that you will be looking at. You'll be again looking at the conduct of various parties, seeing how how everything functions, trying to pull out market reports and everything. So the resources that you have at your disposal will be quite different from the resources that a law firm can put across, or say a company will put across once you have an in-house once you're practicing as an in-house counsel. You can sort of, while you're at both these places, at law firms and in-house, you don't sort of worry about the money, right? If you need to purchase or pull in a report, you bring in that report. Your cost of stationery, your cost of everything is something that you do not look at. So while setting up an independent practice, while looking at the case of the informant, we're trying to only put in and plug in the information, of bringing those information that will be commercially relevant from the client's side. We will not sort of spend extra on any information at all, because then again you need to be aware that the client will only be paying for a certain extent. You don't have that much of financial exposure to you. The third thing will be the guidance that you sort of will have while you are working at a law firm or in-house. You will have a whole team working on, again, with the extent of the filing that goes on, the details, the timelines that goes on, becomes really difficult for an independent practitioner without the help of a team to sort of pack it in. Whoever starts with you, for any lawyer as well, like if say anyone who has joined the session who is a recent graduate or is about to graduate, will try to look in and weigh their pros and cons by the while they are choosing their option. Most of them eye at a tier 1 or a tier 2 law firm or an in-house. Only in the end comes the independent practitioner, unless you're really passionate about setting your own independent practice. So how to bring in the resources in terms of human resource also becomes a challenge for any independent practitioner, right? But then again, I find that some people who have had exposure in competition law for a certain period of time over the years, they build a brand for themselves. They know what goes in and out for competition, and they're quite successful at that. They don't sort of get those challenges that I have mentioned. So it really depends on the time and the stage of life that you try and become independent. I would I have not seen many cases in competition law where someone has started an independent practice right after college, or say working for a year or two after graduating. It usually takes time, and why it takes time is uh, because you need to sort of bring in that trust factors in terms of the client also, that you know what happens in and out of the CCI, what happens in what, and also you need time to gauge that how the CCI will respond to your question. That's something that you learn over the years. And the stakes here are so high that any company, unless they have complete trust on you, will not come to you and give a case to you, be that the informant, be that the respondent. So that's something that experience comes over the year. Unless you attend like 10 to 15 hearings, unless you see that what is happening, how they're gauging, you cannot just understand everything from the order itself, that how CCI perceives a matter, how NCLAT will perceive a matter, what all goes in the back end, how you flowing through, what is the time when you're advising your client to just file an interlocutory application or to go for an appeal. That's something that you will learn over time. So so those are the challenges I think the independent practitioner would face. Once you have sort of that experience on your hand, it's kudos to you if you can establish an independent practice. Nothing like it. It will be quite fantastic a journey, quite interesting a journey for any practitioner. And I
Okay.
think that's a dream for everyone, right? To have their own law firm. Like I'm sure every one of you in their college must have dreamt like once we graduate, we are going to have a law firm of our own. I did that with so many people, and now I see how challenging that might be in terms of putting in my finances, for getting in clients and everything. But back in college, you don't consider all of these things, right? You just want your own law firm there and become a partner, have a smiley setup for yourself. It's
Yeah.
easier said than done, guys, if I can conclude in that perspective.
Okay, ma'am, so can you give us a bit insights on how a young lawyer who has just entered the competition law niche can represent a client in front of CCI or appellate authority in that regard?
Right. So
It would
first,
be great if you can give the answers in pointers. It makes the
right,
absorption of learning a bit easy.
right. Well, thanks for that. So yeah, how? Let me just bring about and break it in the facts that how you would approach the CCI, then at NCLAT, and then possibly if you try and go to the Supreme Court or the High Courts, right? So how you approach the CCI in the first instance becomes it's not the first step to approach the CCI. There is a lot of background that goes in for uh, moving to the CCI. You need to file in your information. If at all you're going through the for a merger clearance order, then possibly that's the first step to approach the CCI and see whether you are exceeding the threshold, whether you need to file in an application or not. That's some discussions that you can have with the CCI in the first instance as well. But more often than not, in the antitrust side, you don't approach the CCI right away unless you have everything on record. Now that you have submitted your information to the CCI, you're not really interacting with the benches of the CCI. You're merely submitting at the office of the CCI, which is not, I would not call it an interaction in the first place, unless you're granted a preliminary conference, which is when the CCI, after seeing your information, uh, sees that whether you need to be given a chance of hearing at all, which is again discretionary for the CCI to give that chance or not. That's your first level of interaction. That happens after some time, right? So then by then you have quite a lot of time to prepare about what are you going to say. It's sort of a hearing that will happen. So you are basically required to present the case of your client. So then you sort of try and building the case again about against the opposite party or against the information, depending upon whoever is your client, what all is the client. So now I'll give you what that you need to be with the CCI. You need to be really on points with whatever is your case. One, you need to be aware of everything that has been the development since you have filed the information. That is second. So let's say that I filed an information 3 months back and there have been some significant developments that are not captured in my information and then. So during that interaction with the CCI, I might present in those information. Three, you have to be really, really thorough about the submissions of the other party uh, at this stage of preliminary conference. Fourth, you need to be really with your client. Okay, so the major aspect of any interaction with the CCI also requires an interaction with your client. You need to be really with your client and make trust with like impart with them the fact that okay, everything is going to pan out as we have planned out. If not, then we should have a plan B. So while your first interaction, you must have the plan B at the back of your mind and also apprise your client about that plan B, right? Those are four things that you need to know about your first interaction with the CCI. Again, if after the preliminary conference there is so there is a whole process that goes in. After the preliminary conference, the CCI might dismiss your case altogether. Then you sort of try and approach the appellate tribunal. It's nothing like that's what happens, right? You don't get always an investigation order against you. So if you are if you are representing the opposite party, there's nothing like getting an order dismissed, right? That's when you bring out your champagnes and pop it out, like, yeah, won the case, let's party, right? And say if you're representing the informant, in that scenario, you are really pressing for a 26-1 order, which is an order for wherein the CCI sort of directs the Director General to start an investigation in your case, and he investigates the entire market. So during that, you need to quite apprise yourself with what all the possible questions that the DG can ask you. So you sort of try and voluntarily submit more information to the DG about the conduct of the opposite parties and how it is affecting the market and you as well. Then again comes the case of what CCI decides in. Does it levy the penalty or does it dismiss the case against you? Whatever may be the case, if the outcome is in your favor, you celebrate again. If it is not, then you go to the appeal part of it. So while you approach the NCLAT, certain things that you have to be really thorough with the whatever has been whatever the CCI has observed in your case, whatever is in your favor or against, goes for both parties, right? So while making an appeal, you need to be really be mindful of the limitation period first. There is a 60-day window that comes in. So whoever is making the appeal needs to know that you need to file that within 60 days. So you have to be on your toes all the time. Second, again, you need to, once you have submitted your appeal, you need to be on the toes with the registry of the of this NCLAT, right? You need to see when they're issuing notices, what has been the responses filed by the opposite party, seek for the inspection in that case. Third, constantly apprise your clients of what all has been the development at the NCLAT. with respect to what all you have been doing. Obviously, you will be pricing your clients for what all you have been doing, but what all have been the development from the respondent side is also something that the client needs to know, and then plan your actions accordingly, right? Fourth, whenever the CCI sort of admits the appeal, you try and engage the seniors as soon as possible to get a briefing on, to know that what all has to be covered during the oral arguments, and sort of start preparing ahead so that you have as much time as in your hand, and then you get the order in the favor of your client. Then again, success and congratulations in order, and obviously you feel satisfied on another level, which is something, the feeling that you get an order in your favor is something which is beyond words. So that's something that
Right.
I cannot even put into word. You have to be there and you have to like experience it.
Okay.
That's something. After you've done that at the NCLAT, same thing follows at the Supreme Court or the High Court. You need to see what all is in your favor, and then again apprise your clients accordingly and everything. Similar
Okay.
cycle goes for Supreme Court as well.
Yes, ma'am. So now we have discussed the independent litigation part, law firm part, in-house part. Now the last thing, what constitutes of employment in competition law is uh, government institutions. So what are the job opportunities in government institutions like PSUs for competition lawyers? And is there what is the criteria except gate? Is it any different from the private institutions or what?
See, with PSU, the standard of recruiting any lawyer remains the same. It's not that something that the
Okay.
PSUs would look differently while hiring a competition lawyer.
Any
Some might
additional
have
skill or something?
additional skills, obviously will sort of help you, but while just making an application, the additional skill does not in the first place help you. Having some experience on competition law side, either through internships or through a job application or through some publication, is something that will help you across your employment chances for any avenues, be it private, be it public avenues, right? But at the first instance, there is no difference for any recruitment for lawyers. You have to go through the similar process. Once that you are recruited is when you can sort of negotiate that you would want that practice area to have. So to my knowledge, like Coal India has a dedicated 2-3 lawyers, not huge, because then again they sort of seek help from external counsels. They engage law firms in, but similar to the in-house practice, the PSUs also have their lawyers who deal with specific sort of areas, mostly their employment, mostly contract related issues or arbitration issues. But companies that sort of facing competition law issues all the time prefer now to have lawyers. So Coal India has 3 lawyers, BHEL has a lawyer, Gale has 1 lawyer that I know of. I am not sure what is the team strength as of now, but whilst I was dealing with them, that's the number that I got across through. So again, like the skill set, to answer your second set of question, Anubhav, skill set would largely remain the same. For any sort of place that you would want to venture in, you would have to know the business of that place where you go in and out. So for example, if I go to a Coal India, I would need to know what Coal India does everywhere. For PSUs, when you target, you sort of try to know how all of these PSUs work, not just so if I'm applying to Coal India, I would not just look about how Coal India works at. I would like to know how Bharat Petroleum works, what all are the organizations that Coal India interacts with, be it private, be it public, be it independent, how are its interactions with the government happening. So all of these things, if you know in advance, will be a skill, will be an added skill set for you. Again, everything beyond this is something that happens internally, is something that you will only learn while you're working there. But if you sort of know these things beforehand as well, that will be a great added benefit for you. So try
Great.
to even, I would say, for anyone who is a student here or who's trying to look at prospects in competition law, once they graduate, try to know how a company interacts with every stakeholder within that relevant market. By relevant market, I would mean the market that the company is functioning at, right? So if you sort of have an hold on that, you tend to know a great deal about that organization, which will help you in a long run, not just in your short-term career plans, right? Not just while you are focusing on recruitment at one place. So if I say I know about Coal India, I might also go to a law firm and say, see, I know the conduct of how this company is functioning, and the CCI sort of had missed looking at this aspect, say an X aspect of Coal India. CCI, while looking at Coal India's conduct, did not see how it interacts with its distributors, right? That's something, that's some added bench that you can look in. And similarly, that goes during your PSU interviews. You can also harp in on the fact that how the CCI has wrongly looked into the distributors' conduct, right? So as in how that you build in the arguments, you once you know the companies, once you know its interaction in the market, once you know the market in general as well, is something that you will be very hands on in during the times of your interview. It will come in handy once you step boots on the ground while you're working. It again comes very handy during your interaction with the clients, right? And it
Great
goes
answer.
through for everything.
Yeah. So I'm speaking of students. You were a scholar, I guess. You had first rank in Alwar district when you were pursuing your BBA. So 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 ma'am, you have interned with tier one law firms like SAM, Trilegal, JSA, AZB, and even in the chambers of Sanjay Jain, who is the Additional Solicitor General of India. So can you share your insights on how law students can secure internship at a tier one organization like you have done, and uh, also a few tips on how a PPO can be scored. So let us start with how internship should be planned, and then we can move on to the part on how we can score internship at the tier one organizations.
Right. So while we are in the law schools, we won't really know what are the practice areas that you would want to work in, right?
Yeah.
You, unless you sort of grapple yourself with various practice areas, you wouldn't know. Of course, there will be some people who are exceptional and who know right by stepping into the college that this is something that I would want to do in. So for all those people, I would suggest, yeah, if you have a clarity in your mind on the practice area that you would want to go in, step into internships right away. There is no better way for a law student to learn and to understand how law works better than doing an internship or a moot court experience as well, right? So for people who would not know the sort of practice areas that they would want in, I would suggest that try targeting different practice area for the first instance. See where your interest lies. That's something that I did. Okay, I had no clue of what practice area that I would want to go in. Competition law was something that was last on my mind. I didn't have any clue about competition law before going to the law school, and actually even not in the law school unless I sort of started my internship, right? So, and there will be 10,000 practice areas that you have no clue about. Say, for instance, there are quite a few law school that there are very few law school that will teach you fintech laws, or that will teach you entertainment laws or TMT laws, right? There are things that you would know only once you, or even if they teach you, you sort of learn that once you go ahead on that semester only. So some courses will be elective that you get in your fourth semester, fifth semester, 10th semester, sixth semester, depending on the course structure that you are in. So if you have to go ahead with that, venture into internships, see the different practice areas that interest you, go for conventional practice areas and unconventional practice areas equally. Find your strengths, right? I would suggest that one should do both sort of internships, go to a law firm as well as go to a litigator. You will see what difference of work happens at both places, and then you can accordingly decide about how what suits your need, right? How a litigator functions is completely different to how a law firm would function. It's more of stay with litigator, it's a little bit casual in approach. With law firms, it's more corporate oriented, formalistic approach while you're dealing with your clients and everything. That's something that you will only learn once you have been at both places and decide for yourself. Also, I've lately been seeing students who have been working, who've been trying to intern with the companies in first place itself. The first internship or the second internship is within the companies, so they also sort of gain an insight of how an in-house lawyer functions. So a diverse, I would say a diverse internship for the first 2 years is very important. Second, now that you know the practice area that you're trying to look at, and fortunately, if that is competition law, then I can probably help him here. So try to see, for the first, be at any boutique firm that you can be. Something that I heard, all right, I did not go to a boutique law firm, and I still regret that fact, that why did I not intern with a boutique law firm? Because the kind of work that you will get on there, the kind of perspective from, again, a tier one law firm will always be, mostly, if not always, say 99% of the cases, be representing the opposite parties, right? So you are not getting the first hand experience of drafting the information, or seeing how the client interaction in terms of drafting information goes out. What are the evidences that you are looking at? What are the annexures that they are putting in? How are you filing an information before the CCI? So because of the size of the law firm, because of the clients that you're looking at, you really have a chance of going actually to the CCI and seeing how information is filed, which I don't think that you will have a chance with a tier one firm right away, because they have the dedicated set of practice, they have the clerks that go on, the lawyers that go on, and the interns will not really have much of a chance of seeing that happening. So after that, you've seen with an independent litigator, go to a boutique law firm, see how that happens, then gradually progress to a tier one firm. Again, on the tier one side, something that you will miss on at a boutique law firm is seeing the merger control side of it. Because again, with the size of transactions, company would rather place their trust on a law firm that has a dedicated set of practice, that has sort of a brand and value, and brings in. Also, these will be the law firms that will be interacting with the clients on the other set of um, their legal businesses as well. So, for example, if I do my employment transaction with an X law firm, I would much rather go to the X law firm for my merger control filing as well. So, something that you can learn at the tier one law firm beyond what we would learn at the boutique law firm would be your merger control. Again, very extensive. You would not even in your dreams think that this is how a merger control works in, unless you like really step in. You see how small things will affect. You will see how, for example, if I'm looking at a fertilizer transaction, during my entire internship I was just making annexures to file, and mind you, this internship lasted for like good 45 days, right? I was only making annexures to be submitted to the Form 1 on how this fertilizer transaction will not affect the market adversely. So I had to look in at every product that this company was selling on, every product that the competitor was selling in the market, with the target was selling in the market, what were the vertical overlaps, and only preparing Excel sheets for this day and night. But the satisfaction that you get after that is presented to the commission, and once the order is out and the commission takes that into consideration, is something different. So yeah, very during these internship, you'll also find that somewhere, why am I preparing these Excel sheet? How is that even relevant? Because you did not do that at your other internships. Certainly your friends who've been interning in different practice area would definitely not be doing that, unless, okay, if some of your friends are doing that in and interning in general corporate, yes, they might deal with that, but they will not do that in other practice areas. So you're not supposed to be disenchanted with the work that is coming in. It's certainly relevant. It's just that it's different from what other practice, what work goes on into the other practice areas. So you might not know about it, but it's relevant. And then it's then on that you would sort of try to gauge your interest as well. If that interests you, like it did to me. So I was working every day, late nights, until 3, 4, 5, and I really did not feel bad about it, because that was exciting to me, to look into uh, different products, to look into what the competitors are doing, how they're pricing the products, whether there will be overlaps or not, how the CCI will look into it. So if that sort of gives you a kick, you know that this is the law for you. You know that this is the thing that I can spend my days and nights on. Because once you step into a tier one law firm, or once you even step into a boutique law firm or go to an independent practitioner in competition law, be ready for the depths and details. So
Precisely.
that's something that you would learn here. With independent, again, that's something on the merger control side. From the antitrust side, while you're dealing with Section 3 and Section 4 allegations, dealing with the opposite parties, you might have chance to see client interactions, see the client calls, see how draft requests are sent to the client. What all something that boutique law firms don't do is uh, send everything to the client, because client here supplies information to you. What opposite parties are, with the size of their businesses, with the time restrictions on their hand, you sort of send everything to the clients in snapshot as well. You send strategy notes to the client, you send RFIs to the client, which is very formalistic in procedure, which all these smaller law firms might or might not do. More often than not, I that's something that I feel, and I've learned from my friends, that that's not the approach in those law firms, right? So all these things are something that you would do. Obviously, again, drafting and researching is something very ironic you would do here as well. So so yeah, that's what goes into tier one law firm. If you're interning with, say, an in-house, again, you will be dealing with the practices of that entity only. You will be dealing with how the information is shared with the external lawyers, how the team is preparing to share information during a merger control filing, or during an investigation, or for an abuse of dominant position case investigation that has been going on how the companies are sharing information with the CCI, what are the sort of information that they're sharing with their external lawyers, when they're placing the barriers that no, this is not something that I would want to share at all, are something that you would learn during your internship. And whilst you start working, you, wherever you sort of work, if you've interned at a boutique law firm and you sort of go to a in-house counsel, you will know what happens during the information stage. You will vice versa, if you have worked at an in-house counsel chamber and you sort of come to a tier one law firm, you will know that this is a place where in-house counsels and the companies would put a back on that this is something that we are not going to share at all. uh, Again, during my internships with Sanjay sir, what exposure I would get was to see how hearings are conducted for the CCI. He was representing the CCI for quite big matters at Delhi High Court back then while I was interning. So how those hearing plans out, how the CCI. So because when you are interning with CCI, all you're doing is you are sort of helping the commission with case laws, you're helping the commission on whatever work is assigned to you, that is towards a 26-1 or 26 or 2 order that will come into you, or for the 27 orders. How the appeal goes on, how the CCI then interacts with the appeal, how the officials from the CCI put in, what are the contents that go in during the argument, what is the preparation for the arguments that happens before you step your foot on the court. uh, what are the things the CCI would require you to say, how the lawyer sort of refines that. um, and that's something that you would also learn while you are doing an internship with the senior counsel as well. So I would suggest that intern at some with some lawyer who represents the CCI, because then you'll get an insight of how the CCI comes into picture, and also how senior counsel would work for the opposite party, because the working kind of is similar.
Precisely.
All of this is something that I've learned during the internship, and something that all prospective students and graduates should also look at.
Oh, great answer, ma'am. And the PPO part?
Yeah. So yes, wherever that you have worked on, say for the first thing, that while if you are at all looking at a PPO at a certain organization, you need to be really sure that you can commit yourself to that organization. something that you will obviously sort of figure out while you are interning. The best practice is to be really meticulous at everything that they have been doing upon. Obviously, I'm not saying that uh, to be meticulous means that you perform every task that has been given. You sort of try your best to do whatever is given to you, be it any research, be it any drafting, be it small tasks. Okay, do not consider anything to be small. If you, at some places where I secured a PPO interview, I was working for 3 days only getting some sort of documents photocopied and stapled so that they could be presented to the court. And that actually, while I was getting interviewed, I was actually praised for that, saying, again, I am telling these experiences because these are personal things that I have sort of seen, what worked with me, what did not work with me, right? So that's something that I was praised at, that you can show diligence to small works as well. Uh, giving assisting your seniors on everything is something which is very important. Again, presentation that I had said earlier is important, that you give them a sort of holistic view while bringing say a research. You also apprise them of what all could be the counter argument to your research. Take every day as if this is the day when you can secure an interview. Perform every day as if that's the D day for you, right?
Yeah.
Prepare every, know about the firm while you are trying to take a PPO at any place, or while you're envisaging a PPO or aiming at a PPO. The first step is to know the firm or the lawyer in and out, what they do. And if you're looking at the practice area, and if you're specifically set on the competition law aspect, know what the competition law team does, know what all would be required for you, and you will get substantial idea after interning for say 15 or 10 days of what the team does, what will be required of you once you start your practice with the firm, because you'll see junior lawyers, what kind of work the junior lawyers are doing, what sort of assistance are you getting on. That's something that you will have an idea of. Start preparing for your interview from the day one. I'm not saying that you will be getting an interview call, but you should in your head think that you're definitely going to get an interview call, and you should be preparing for that interview. You should know the matters that you have worked on. You should know entirely everything that is on your CV. You should be aware of uh, end to end of what all has happened on the transactions that you have worked on. Say for some transaction you have merely worked on a case law research, right, and you have nothing else to do beyond that case law research, but you need to know what that matter is. Why is it that the senior has asked you to research upon that said matter? How is that going to be used in that matter? So while your interview, you will be asked all those questions, and your PPO interview is mainly based on the work that you have done so far within the team. There will be questions on what all you have done outside that, internships as well, but primarily it is based on what you have done within the team, right? So knowing everything that you have done on the team, also sort of uh, no, you need to keep a tab on, if at all it is possible, because everything is so classified, you will not know everything that is going on within the team, all the transactions that are going within the team. Certainly if you have an idea of the live transactions that are going, like by live transactions I mean the matters that the lawyers are actively working on. You might work on it, you might not be assigned work on it, but if I have an idea of what is going on, what is the present practice in that case or in the relevant market, or how the team is approaching, also give an insight on whether you agree with the contentions that have been put on, if there is something that you can add on, uh, that's something that will go a long way for you.
Yeah.
So that also, prepare your CV, tailor make your CV beforehand for that law firm that you are looking, that you are targeting at. Say for example you are targeting a trilegal competition law team at trilegal, your CV should be prepared beforehand, because they sort of try and conduct the interview at the spur of the moment. You will not be given an advance notice. The HR just comes in and says, okay, you have an interview with the partner, be prepared in 2 hours. What if you don't have a CV in hand? Are you going to give a CV that you have given for an internship, and there might be an addition to that? Because generally with tier ones, you sort of give your CVs 6 months back, and then you get internships after 6 months. There will be much that has happened within 6 months, and if
Courses.
that's standard,
Yeah.
and if that's standard, it really falls back. Also, while you are taking a PPO interview, something that really works in your favor is that if you've done some publication in competition law, if you have some moots in competition law, and how did that experience pan out to you? What new points that you have found in? What's something that has been interesting you? Uh, that if that you have in your CV, that will go a long way for you.
Yeah.
It's something that you will have added to the other interns out there, or other competition that you will face also during the campus placement or separate independent applications that people send in.
Great answer, ma'am. Very, very, very
Performance,
detailed.
guys, becomes the key right here.
Yeah. Exactly. So, ma'am, as we are running out of time, I have one last question with you, so that so just answer it briefly, so we can open the forum for the questions of attendees. So, how you think lawyers, the competition law lawyers, sorry, what I'm saying, competition law aspirants can make the best out of this pandemic situation?
Again, young lawyers, students, recent graduates, read as much as you can. Read on the transactions that the CCI has approved. They're still looking at the green channel green channel transaction. You can still file in notices. So see whether new orders are coming in, how the CCI is looking at the transaction. As Anubhav had mentioned in the questions about all the digital economies, the players in the digital economy, what are they panning out on? Because certainly their operations have not stalled. The other operations might get stalled, like you can't get a new truck out in the market, you can't get something in the cement out in the market as of now for the present day. But the digital economy is still functioning with the speed that it does, obviously with some caution. So see how they are responding to this challenge. Uh, Read upon read upon articles, read upon books for the foreign jurisdiction as well. I would say focus on India and EU as much as you can. Try writing something if at all you have the time. uh, I myself, while if I'm during the regular days, as I've said, long working hours, you don't really get in a lot of time. So I try to put in some time, whatever I can, to write something, because it really goes out a long way. It will give you sort of skills to put in arguments briefly, and also present your own viewpoint, give how you have an understanding of the market in that sector. So that will go a long way if you can utilize this time this way. Also, be safe, be at home, don't venture out at all. Do everything within your homes. Okay.
Great answer, ma'am. Thank you so much for all the great insights you have shared with us.
Thank you,
Uh,
Abhinav. Those questions were really exhaustive. You covered everything from end to end, huh?
I'm learning from you. So okay, ma'am. We started with a attendee count of 125, but only 153 are left. But sorry, 53 are left. But
Right.
these 53 people are who genuinely interested in competition, who genuinely wants to get enlightened on the topic. So now I'm opening the forum for the question from attendees. So guys, now you can ask, ma'am. Shoot. Do anyone has any question? People, you were asking a lot of questions in the
Yes,
chat
Anusha,
box.
please tell us what is it. Could you please suggest some names? So yes, the names of boutique law firms that I was talking about would be Chandyok and Mahajan, somewhat like Gaggar and Partners. So all of these would say have relatively better work from the informant side. They also represent the CCI in some matters. So you'll have chance to get hands on both the sides. Please look at that. Okay. So
Next
after
question.
COVID-19, see the recruitment will remain the same, Anuja. It's not that COVID-19 will affect the recruitment chances for you. What you can do well is to read upon, to build upon your knowledge bank as much as you can, and yeah, face your interview. Good luck. What
Hello.
the compliance work in competition law? So compliance work initially in competition law would require you to assess your clients on merger controls, see whenever any transaction that needs to be notified, quite keep your client updated on dawn rate practices, see if and when the company can be subjected to dawn rate, and also uh, give an input on that. So, Anjali, as of now, I'm working at P&A Law Offices, Pathak and Associates, and the team has been great so far. Whatever I have learned on competition law and workings with CCI is at P&A. Good work, yeah. I'm thoroughly enjoying it. I get to do sort of different work than what I have done, and I'm really enjoying. I wish you could intern and see how the team functions there.
I want to know in market are law firms are in more count or individual practitioner in competition law are in more numbers. I'm talking about
See,
and hmm,
see, if you search on Google, you'll find only limited law firms that have a dedicated competition law practice. But then every law firm has one or two lawyers that, even if they do not have a competition law team, they will have lawyers that will work on the transaction as and when the work comes in. So again, there's lot scope for the law firms, but independent practitioners are also coming up in great numbers. You won't find a dedicated independent lawyer so much as you would find law firms. But then again, as in when the work comes in, independent lawyers will also take charge of competition law matters. You can look up for practitioners. There'll be quite a few that are working with CCI that are impaneled, and you can easily get hold of them. You can see how they're working with, how they're working on while you're interning with them or you're interacting with them, and see how it pans out for you.
Yeah.
Can you mention one or two countries that India competition law is closely compared with?
I'm sorry, I
Camera.
couldn't hear you. Could you please
Yeah.
repeat yourself?
One or two countries that India competition law is closely connected with.
See, the Indian competition law derives quite a lot from European Union, right? So whatever cases happen, we actually first instinct we see what the CCI has said upon the matter, and then we go to the European Unions and learnings from the European Unions. Next, if we find something from the European Union, we try and find something from the US jurisprudence. We rely on emerging jurisprudences as well. It's not that if you have something from EU and the US, well and good, but you can also substantiate your workings with other jurisdictions, the upcoming ones as well. So you see Australia, you see how Brazil is functioning, you see how Hong Kong is doing. They've recently done it. All of these countries, yeah. You see how UK is doing. CMA becomes very important. Also, Germany is something which is coming on quite a lot, and the rulings, the practitioners in India rely on a lot of German rulings as well, because they tend to take a lead, and then similar investigation sort of follows in India as well.
Okay. Great answer. Next. So Vishal Sharma's question is.
Yes, I'm Arvind Kamath here from Bangalore.
Hi, Arvind.
Yes, madam. Since we joined a little late, a little brief introduction about
Right.
yourself and your background will help us.
So Arvind, I am presently working with Pathak and Associates in the competition law practice team. I have worked as a research associate at NLU Delhi's competition law cell. I've worked at Competition Institute for Regulation and Competition again as a research associate. I have graduated from Faculty of Law, Delhi University in 2017. So it's been 3 years of practice.
Faculty of Law.
Right,
Faculty
from
of Law.
University of
It's a
Delhi.
college. Yeah, it's a college, is it? Law college.
Yeah. Arvind, it's a
Yes,
college.
it's a
Oh,
law
acha, acha. All
college
right, all right.
for
Because you know the
University of
fact.
Delhi.
All right, all right, all right.
Ma'am, this Vishal Sharma has a really interesting question. In case
Right, Vishal.
CCI does not agree with the report of DG and concludes that there is no contravention, in such case, whether there is an option of appeal or not.
Absolutely, absolutely, Vishal. If the CCI finds no contravention and dismisses your case under 26(2), you can actually go and appeal to the NCLAT saying that the CCI has not relied upon the DG report. The DG had sort of found contravention, and justify your case saying that you actually agree with the DG. DG has taken the right stand, and therefore leave it for the appellate tribunal to decide the matter on merits.
Okay,
And there
people.
have been many instances when the orders, when the CCI has not relied upon the DG report and people have appealed and have been successful in appeal. So again, one point that I would like to bring about is only that the orders that have achieved some sort of finality will be appealable here. The 26(1) order that only directs investigation cannot be appealed at the NCLAT. So while trying for appeal, you need to sort of take a look at that. Any digital resources where, of course, Vashish, there are a lot of digital resources that you can look at. You can look at GCR, you can look at IGLI, you can look at GLI, you can go to the Competition Commission's website and search for the orders. You can search for NCLAT's website and look at the orders there. A lot of market studies are there on the Competition Commission's website. You can also looking at the website of various law firms and independent writer. Also check in LawSikho's website. They have a lot of material on competition law, which will be really helpful. Please make as great use of your quarantine days as much and read about market and read about competition law if you're genuinely interested in. You can also download Richard Wish and start reading upon it.
Okay, ma'am.
It's a
So,
great book.
thank you, ma'am. So, ma'am, with this, it's time for us to bid them adieu. Thank you so much, ma'am, for being here,
Thank
for
you, Anubhav. It was
walking an
really
extra
great
mile.
session.
Yeah, for walking
Thank
an extra mile for us and giving us 50 more minutes. It's almost double the time we decided. So, thank you so much.
Thank you, everyone who's joined. I hope you stay safe, and I wish you all the good luck for your future prospects.